All right. I think it's working. It's very nice. Well, first, I would like to make some institutional acknowledgements. So I will ask permission to talk in Portuguese, but then we are going to speak in English. It'll be our common language. Eu gostaria de desejar a todos e todas uma boa tarde para o nosso terceiro encontro de debates sobre sustentabilidade, proteção ambiental, migração, COVID-19 e seus desafios na efetividade dos direitos fundamentais. I was saying that I was greeting for our third meeting of debates on sustainability, environmental protection, migration, COVID-19, and their challenges in the effectiveness of fundamental rights. And I would like to make some institutional acknowledgements for Reitoria da Universidade de Itaúna, os meus agradecimentos, na pessoa do professor Dr. Faisal David Freire Schecker. Também os agradecimentos para a coordenação do mestrado e doutorado da Universidade de Itaúna, na pessoa do professor Márcio Eduardo Senra Nogueira Pedrosa Moraes. Também para a professora Lilian Nassara Schecker Bueno, que é a coordenadora do curso de Direito da Universidade de Itaúna, bem como para o subcoordenador, o professor Fabrício Veiga Costa. Temos também como apoiadores institucionais a Cátedra de Excelência Jean Monnet e o Grupo de Pesquisa Integração, Estado e Governança, por intermédio da professora Jamile Bergamachini Matadiz. Não poderia deixar aqui de fazer os meus registros de agradecimento para a Universidade de Caxias do Sul e o Grupo de Pesquisa Metamorfose Jurídica, na pessoa da professora Cleide Galgaro, que se encontra. Seja muito bem-vinda, professora. É sempre uma honra contar com a sua parceria, com a sua amizade. Também ao Grupo de Estudos Araquém de Assis, conhecido como GEAC, que é liderado pela professora Mariângela Guerreiro Melhorança da Rocha. Ela justificou a ausência porque ela está fazendo mudança de residência, né? Então, vocês já sabem como que é essas atividades de mudança. Aqui também os meus agradecimentos para a Escola Superior Dom Helder Câmara e o Programa de Mestrado e Doutorado em Desenvolvimento Sustentável da Dom Helder, com a presença aqui do coordenador, professor doutor Magno Federici Gomes. Então, eu vou passar a palavra para o professor Márcio, para que faça a abertura do evento, e após, então, eu passarei para os palestrantes.
Boa tarde a todos. Gostaria de mais uma vez agradecer a presença de todos vocês nesse evento, dos alunos, dos professores, professora Cleide, que está aqui, os demais professores do programa. E eu vou então fazer uma breve apresentação também, pedir licença porque nós temos aqui convidados que são falantes de língua inglesa, então eu vou pedir licença para que a abertura seja feita então em língua inglesa, tá? Antes disso, concluindo, gostaria de agradecer mais uma vez a participação e os trabalhos, a ajuda que o professor Deilton tem feito, né, junto ao programa, nos ajudando nos eventos. Gostaria de agradecer a todos os funcionários envolvidos, na reitoria da Universidade de Itaúna, a pessoa do professor Faisal Freire Schecker, a graduação também em Direito, porque é fundamental que haja uma ligação, uma interseção entre a graduação e a pós-graduação, porque ali na graduação, nós temos o locus de nascimento, ou nascedor, então, de muitos dos nossos futuros mestrandos e doutorandos. Então, isso é muito importante. Por fim, repito o agradecimento aos alunos. Sempre digo que o programa de pós-graduação ele só existe porque existem os alunos. E vou pedir licença para repetir o que eu tinha falado hoje mais cedo, em outro evento, em uma outra instituição, tinha falado para os alunos, reforçando a necessidade de uma pesquisa séria. Nós precisamos de mestrandos e doutorandos comprometidos, pessoas que realmente suem a camisa, que realmente façam uma pesquisa séria. O mestrado e o doutorado não pode ser enxergado como um detalhe. Infelizmente, a gente tem visto que em vários lugares o fato de você estar cursando o mestrado e o doutorado tem se tornado um detalhe. E muitas vezes, muitos alunos, obviamente que eu não estou generalizando, estou fazendo aqui, na verdade, uma observação pedagógica, né? É um recado, digamos, de um pai para um filho, entre aspas, aqui. A gente tem visto que se dedicam a tudo e, se sobrar tempo, se dedicam à dissertação e à tese. Isso não pode acontecer, principalmente pelo fato de nós vivemos num país de terceiro mundo. Nós vivemos num país subdesenvolvido, como queiram aí os geógrafos denominarem essa classificação, mas a gente vive num país que está precisando muito de ciência, que está precisando de conhecimento genuíno, isso é muito importante. E, infelizmente, a gente tem visto que o conhecimento no Brasil, em certo ponto, ele tem sido desprestigiado em várias frentes. Então, o meu apelo seria no mesmo sentido do apelo que eu fiz hoje mais cedo para os alunos, para que realmente a gente melhore aí as nossas pesquisas. A pesquisa, uma dissertação, uma tese, não pode ser simplesmente para se concluir um curso e conseguir um emprego melhor. Tem que ser realmente algo com uma função social e que efetivamente possa, de alguma maneira, contribuir para os estudos. Let's go. It's a pleasure to be with you at this 30th debate meeting on sustainability, environmental protection, migration, COVID-19 and its challenges in the effectiveness of fundamental rights, promoted by the Strict Censor Postgraduate Program of the University of Itaúna, Brazil. I would like to thank the director's support in the person of Professor Faisal David Freire Schecker, as well as the support of the academic secretary and all the professors involved. On behalf of our students, I greet Professor Tatiana, thanks a lot. Professor Stephanie, thanks a lot. Professor Helena, thanks a lot. And Professor Matia, thanks a lot. I thank the event organizers in the person of Professors Deilton Ribeiro Brasil, Cleide Calgaro, Mariângela Herrero Melhorança, Fabrício Veiga Costa, and Magno Federici Gomes. Thanks a lot, everybody. Thanks for sharing your afternoon of knowledge. Lots of health for everyone. I declare the works open. Muito obrigado, professor Deilton. Declaro os trabalhos abertos.
Muito obrigado, professor Márcio. Passo a palavra para o professor Magno Federici, se quer fazer alguma consideração inicial. Uma coisa rápida, caso a professora Cleide queira também. Professor Magno.
Okay. Good afternoon to all. To the speakers, on behalf of the John Elder Camera Law School and the other institutions that promote this event, I would like to thank you for being available to give us lectures to our students. For us, it's extremely important to acquire an international perspective on the world and the law. Knowing other realities will certainly influence our scientific research. Thank you very much, and I ask those present to pay the utmost attention to future lessons. Thanks.
You're welcome, Professor Magno Federici Gomes, and I would like to say that I'm very happy to have the lectures here for this afternoon in Brazil. I know it's evening in Europe and Russia, and I'm very glad. I think the pandemic situation is difficult for every country, for worldwide, but in the opposite side, we have the opportunity to meet each other with the internet and the new technologies. I think it's very interesting because our universities, we need to strengthen the academic relations, and it's a good opportunity. Of course, in the near future, we shall invite each of you to come personally to our university as soon as the pandemic situation it ceases. But until there, of course, we shall meet each other frequently. Well, the first lecture is Professor Dr. Tatiana Zoroska-Kamilovska. I think the pronunciation it's correct. And I'm very happy because Tatiana, as Tanya, as I would say, I met with her and her husband 2 years or 3 years ago at Salamanca University. We had a dinner together, and we spoke a lot about Macedonia, North Macedonia, its history, and lots of interesting subjects. I never forget that. And please, Professor, be welcome at the University of Itaúna. We have Dom Helder Law School and also Caxias do Sul University. There are 3 institutions, 3 universities in a joint seminar. Well, Professor Tatiana is going to talk about the impact of the COVID-19 pandemic on conducting civil proceedings, lessons learned, and future directions. So, Professor, it's up to you, and we are all very pleased to listen to you.
Thank you very much, Professor Brazil, for these kind words of introduction. I hope that I deserve each. Good afternoon to everyone. Indeed, it's evening here in Skopje, but the most important is that we are all together at Google Meet. So, ladies and gentlemen, dear colleagues and friends, let me wish you a convivial welcome to this seminar. At the very outset, I would like to express my gratitude to the organizers, especially to my whole dear colleague, Professor Deilton Ribeiro Brazil. The pronunciation is good. For providing me this distinctive opportunity to deliver a lecture at today's seminar. By delivering a lecture under the title that has already been announced, my idea was once again to address a topic which doubtlessly is one of a cluster of burning issues concerning the administration of justice, or more precisely civil justice in current crisis. Namely, during the last years, many studies have been conducted, many webinars regarding the impact of COVID-19 on judiciary and challenges to rendering justice during and after the pandemic were held. Hence, many academics and practitioners have had the opportunity to share their experience, but also predictions on how the civil proceedings landscape would be shaped by the pandemic. Today's lecture will be my contribution to this debate. For sure, in this short lecture, it will not be possible to provide a complete picture of the impact of COVID-19 on civil proceedings worldwide, especially because of the diversity of jurisdiction and their specific context. But however, some general trends can be identified. In this vein, I try to pull together experiences and concerns from various sources in order to provide some stark context of the debate. My aim is to point out the multifold and varied procedural changes that occurred in different jurisdictions, but also to try to predict those that may persist even in modified form once the pandemic will be over. Dear colleagues, let me give you a very short introduction. Approximately 14 months after the pandemic was declared, it became somehow superfluous to speak on how COVID virus had radically changed the daily lives of people in entire planet. It paralyzed not only the entire social life and relation, but also deeply affected the functioning of private and public institutions, political and commercial sectors. In these terms, the judiciary as a key institution that steps in as a guarantor of human rights and the rule of law was not disregarded by this monster. On the contrary, it has been tested more during this pandemic than ever before. And the question is, of course, why? I would say simply because the current crisis caused by COVID-19 is unique and significantly differs from all other past crises. Many past crises, such as public calamities, natural disasters, and armed conflicts that resulted in the state of emergency, and various emergency or intervention measures, are usually short-term. So the institution, including judiciary, were generally able to return to the state of normality relatively quickly. The current crisis is enduring and with no clear end in sight. So far, its completion by the end of 2021 or even the first half of 2022 seems to be a rebuttable presumption. Therefore, the judicial responses to the current pandemic are still a work in progress, meaning that the taken emergency measures can easily become a long-term strategy for the functioning of judiciary. On this occasion, our focus will be on the administration of civil justice and conduct of civil proceedings. The key questions are what we have learned and how we should establish civil proceedings for future quick response in same or similar situation. So let's go step by step. A starting point of my analysis will be the premise that the nature of judicial system is tremendously social, and majority of judicial proceedings, including civil ones, involve some form of in-person contact. For example, in-person filling of submissions, court appearances, hearings, oral testimony at evidentiary hearings, publicity of trials, and so on, thus putting each participants in the proceedings at high risk in the context of current pandemic. Various forms of summary proceedings or document-only litigation or online, even online proceedings that exist in many jurisdictions prior to the pandemic do not change the perception that civil proceedings are very much alive. So once the pandemic was declared, it was obvious that measures have to be taken in order to prevent the courts from becoming virus transmission hotspots. But the critical questions were: how will these measures affect the access to justice, due process, and fair trial standards? Or would it be possible to balance between the concept of open justice and various restrictive measures? Let's sketch how the judiciary was and is still navigating through these challenges. From the very beginning of the pandemic, after declaring a state of emergency or other similar exceptional regimes in many countries, a wide range of measures have been undertaken, and they were regularly updated as the scientific knowledge of COVID-19 develops. My comparative analysis shows that at national level, the assortment of measures taken by the states regarding the conduct of civil proceedings is widely similar. Many states adopted decrees, regulations, or orders that mainly affected the following procedural issues. First, time limits in civil proceedings. Second, in-person hearings. And third, the issue of remote access technology. Let me go measure by measure. In majority of jurisdictions, including, of course, my country, North Macedonia, once the state of emergency was declared, procedural time limits, including limitation periods, were immediately suspended or terminated for a certain period of time that differs from state to state. For example, they were terminated until 28th of May 2020 in North Macedonia. It means that at least during the first wave of the pandemic, many states have largely closed down their courts for extended periods, that thus affecting both ongoing civil proceedings and proceedings to be initiated. Of course, exceptions were made for so-called priority or urgent cases, for example, child protection, some other family matters, provisional measures, and so on. In addition, many states have suspended payment deadlines and also insolvency triggering events in order to prevent the initiation of enforcement or bankruptcy proceedings, but once again of limited duration. Some other jurisdictions have chosen more flexible approach. It was for the courts and judges concerned to decide on these issues and to take appropriate measures on a case-by-case basis, taking into account the regional and local spread of the virus. The same findings can apply to the holding on in-person hearings. In many jurisdictions, as it was in my country, in-person hearings have been generally postponed for extended period of time. In some states, oral hearings are only taking place for urgent matters or so-called essential proceedings, while in other states or jurisdiction, it was left to the discretion of the courts and judges to schedule in-person hearings. Since I have a limited time for this lecture, for more comprehensive understanding of these measures in different jurisdictions, I refer you to three very important studies or reports. For example, first, for European context, you can see the comparative table on COVID-19 impact on civil proceedings in EU member states, which is available at eJustice Europe website. Then, for example, the ILAC report titled as Justice in Time of COVID-19 Challenges in the Judiciary in Latin America and Caribbean, published in December 2020, entered the IBA report, the Global Impact on COVID-19 on Commercial Dispute Resolution, which is also available on IBANet website. Generally, it can be concluded that the measures of this kind reflect the level of readiness of the judiciary for quick response in mitigating the exposure to the pandemic and controlling its spread. Once the first wave of the pandemic was over, it became evident that the judiciary, as one of the essential services in society, has to continue to operate besides the temporary national lockdowns that may be repeated. As a result, in many countries, as it was in my country, the civil proceedings have returned to normal physical proceedings with reduced schedules and, of course, by adhering to the sanitary measures. But in considerable number of states worldwide, the way litigation has been conducted has changed substantially. What I mean by the latter, namely, in many countries, though with different pace, of course, the use of remote access technology, or so-called digital justice, became a backbone in conducting civil proceedings. The capacity of digital justice tools are already in place, both in statutes or procedural rules, and as available infrastructure vary a lot from one jurisdiction to another. Those which already had some type of digital tools in place continue to use or even expanded them on new types of cases, such as civil, family, commercial, and labor cases, so they were able to function efficiently during the pandemic. Allow me to mention some of these digital tools. For example, electronic submissions using the online case management system, which replaced the paper-based submissions, then electronic notifications and service of process, then conducting the hearings by means of teleconference and video conference like we are doing now, then public access by way of allowing a media representative or interested party to join the remote hearing, or by way of live streaming of oral arguments, and so on. In order to provide solid legal basis for the use of these digital tools, in addition to the rules of procedural codes or acts, the competent authority in respective states issued orders or guidelines that comprise the best practices for remote hearings. If you analyze these orders or guidelines, you will find out that their essence is to replicate as closely as practically possible the core requirements of in-person court hearings. For example, you can find and read the Florida Supreme Court Administrative Order 2023, which contains an excellent protocol for remote witness testimony. Many have been surprised by the spread with which some jurisdictions have adapted to virtual working, I mean in judiciary. For example, it was reported by the Lord Chancellor that up to 90% of all hearings in UK have used remote technology. Alike, Justice Perrin of the Federal Court of Australia, as early as May 2020, observed that he doubts, I quote, what had been achieved in courts in terms of technological take-up over the previous 8 weeks could have been achieved in 10 years under normal circumstances. And what is more important, I found no studies indicated an increase of the overall cost of conducting proceedings online rather than in physical proceedings. Of course, on the other side, there are jurisdictions that have no digital tools available prior to the pandemic, neither in their laws nor in practice. So they have to adapt the new procedural rules in response to allow the digital justice at first place, but also to start building the remote communication technology infrastructure in their judiciary, which requires time and financial resources. Some of them have reacted efficiently and speedily, engaging third-party technical service providers to offer online litigation platforms. However, generally speaking, either rapid or gradual shift towards new remote technology in the judiciary is welcome. However, it does not come without doubts and concerns. Apart from the reported technological and other difficulties which were experienced by the participants in the setting up or in the conduct of remote hearings, various concerns about the remote justice tools have been expressed, especially in the light of the fair trial standards. Luckily for me as involved in civil procedure, they mainly relate to criminal proceedings and necessity to exercise the right of defense in person. But of course, there are some doubts and concerns regarding civil proceedings. For example, although it is undisputable that remote hearings especially using video technology, preserve most of the benefits on the oral hearing, allowing party and the court to interact with each other on real-time basis, some studies suggest, for example, that remote hearings were worse than hearings in person overall and less effective in terms of facilitating participation. And you know, I hope that facilitating participation is critical component of procedural justice. Therefore, in civil proceedings, remote hearings are recommended primarily when the case is likely to be less contested and where both parties are represented by lawyers. In this occasion, not to forget to mention the concerns about the cybersecurity control and the protection of personal data, which of course must be a priority. And now finally, what's ahead? From my point of view, the ultimate lesson we have learned from this pandemic is that the administration of civil justice cannot come to a total standstill, whatever the circumstances. Therefore, measures at suspensions, adjournments, or extensions in the administration of civil justice and conduct of proceedings might have only a short breath. In a long run, they are counterproductive as they hinder the access to justice and create huge court backlogs. Therefore, with due respect to all doubts and concerns expressed for the use of remote access technology, it seems to me that the implementation of various forms of remote justice tool will be the benchmark of the functioning of the judiciary in the future, either as a new norm or at least as more widely offered option. Of course, the impact of the remote civil justice procedure on the right to a fair trial should not be ignored. Nevertheless, the current crisis clearly shows that the standards of fairness are not immutable, and the requirements of fairness are flexible and closely conditioned by the legal, technological, and wider socio-economic context. By this, I do not mean that the use of remote access technology into the judicial system has to be pushed, I would say, on a prodigious scale. On the contrary, from my perspective, all that needs to be done is rationally, without resistance, and in the light of the currently introduced emergency innovative practices, first, to reconsider some aspects of traditional court functioning and conducting proceedings, and to identify cases and procedural activities that are suitable and can capitalize on the benefits of remote access technology, and second, to allocate financial resources and invest in the necessary information and communication technology needed to conduct proceedings online, of course, with the widest coverage of the territory and the population in the country, which is very, very important. Dear colleagues, I do believe that only with such an approach and looking forward, the administration of civil justice will emerge as more efficient, more dynamic, and more resilient following this crisis. I will close my lecture with these words. Albert Einstein seems to be right. Crisis is a time of ingenuity, discovery, and great strategy. Thank you very much for your attention.
Congratulations, scholar Tatiana Zoroshka, and I was listening to you very carefully, and congratulations to your British accent, your British pronunciation, very clear English, and it's easier to understand. And I think it's very interesting, and the question or the topics of access to justice, fair justice, and especially in this pandemic situation. And I would like just a small commentary about how children migrants without remote access. Do you have cases in North Macedonia, especially migrants, children that do not have access to education? Because it's a fundamental right, and of course it is related to access to justice, because migrants, children migrants, of course, without remote access, may go to the justice to ask the state to give this opportunity for them. Do you have this case, or you can talk something about?
Thank you for your question. It's a very good question indeed. But as I know, we don't have such cases in Macedonia. Even we are part of the migrant route, but I'm not familiar with these type of cases. I'm sorry that I can't provide you information on this particular question. Maybe some of my other colleagues, but I agree with you that it is very important, this migrant children, to have access to justice by using these digital remote tools. But I don't know the situation in my country in this particular category of person.
Yes, I understand, because it was for curiosity, just for curiosity. But very interesting your lecture, and of course we have to reflect and think about. So I don't know if my colleagues would like to make a question. Professor Magno, so please.
Congratulations to your lecture, Tatiana. It was quite interesting. The conversion of civil physical procedures into electronic civil procedures was one of the consequences of the pandemic here in Brazil. The first wave of access to justice for Capelletti and Garf from the Florence School provides for enlarged to access to jurisdiction. How does the scholar Tatiana see the access to justice on the part of older lawyers who are less accustomed to digital tools? New congratulations and thanks for the lecture.
Thank you very much for your comments and kind words. I know that the use of these digital tools for this category of older lawyers or persons, even parties that are participating in the procedures and that are not familiar with this new technology, IT technology and digital tools, is very problematic, not only in Brazil, not only in Macedonia, but I would say worldwide. Of course, some countries in these regards are maybe more in a higher level. I speak with general person and in general, but in these regards, I speak in my lecture that there are many concerns about the use of these digital tools. Maybe I didn't mention this particular concern about the use of digital tools from the, let's say, older generation, but it seems that it's obvious that in each country it's a very huge problem. Maybe not in Slovenia, because as I know, Slovenia is very much digitalized and have very good IT infrastructure in general and in courts, but in countries like, I suppose, Brazil and Macedonia, as for now, it's a very huge problem. Maybe Mattia will comment something on the situation in Slovenia.
Thank you.
Yeah, as far as I know, Slovenia was in fact also quite slow in transitioning to online hearings, because there were some courts that are equipped appropriately, but not all of them, and it's the problem also with the parties, whether they are ready to do that or not. I know a friend of mine who is a judge at the commercial division of the district court. He used this online hearings quite a lot, because in commercial cases you only deal with lawyers on both sides, mostly attorneys, so that worked for a while. As far as I know, in criminal cases, online proceedings were not used at all. In civil cases, occasionally, but I can't say that it was a great transition to the online world in judicial proceedings, at least. But we're going in that direction in a way, so we'll see what if something from this will be preserved for the future. I can imagine it would be mainly useful in cases when you have a witness, or maybe an expert witness, which is located in a different country, like in Brazil or something like that, and it makes no sense for them to travel just to hear them in court. But generally, I think it's still better for the parties to have hearing live whenever it's possible. So this should be just a backup option.
Thank you, Tatiana. Thank you, Mattia. And now I would like to call
the audio.
Yes, you're welcome, Professor. And I would like to call.
We can hear you.
Oh, thank you. Excuse me.
Okay.
Many thanks, Tatiana. Many thanks, Mattia. And now I would like to call Professor Stephanie Holfin Dijou, and I would like to see if Professor Stephanie, she was here. I could see.
I am.
Oh yes. I see you now. Oh, I'm very happy to welcome you at the University of Itaúna. Be welcome, and with our warmest regards and wishes. I met with you, I think 2 years or 3 years ago at Salamanca University.
Salamanca also, yeah.
Yes, Tatiana was also at Salamanca University for the Paris-Nanterre Congress.
Meeting, yeah.
Yes, it was very interesting. Well, Stephanie, I would like to introduce to you my colleagues. We have 3 joint universities here in this seminar. We have Professor Magno Federici Gomes from Dom Helder Law School from Belo Horizonte, Cleide Galgaro from Caxias do Sul University, it's in the south part of Brazil, and also our coordinator Márcio Pedrosa. He's the coordinator of our master's and doctorate degree at Itaúna University. And as I said, I'm very glad to receive you. I remember our Congress. I have good thoughts, good remembering, and I think it'll be not the first lecture, but will be the first lecture of many lectures. And I think it's very important also to establish and strengthen the academic relations between Brazil and France. I think it's very important also to have French scholars here to talk with us. I think it's very important. And so, Professor Stephanie, I know that you have a presentation, and Rafaela Cândida is going to help to make the presentation for you. Yes?
Perfect.
I think it's working.
Okay.
She works very well. She is our doctorate student. And thank you, Rafaela. And be welcome. And after, I would like to exchange some words in French with you.
Thank you. Okay, so thank you very much to all the universities organizing this event. And my thanks also goes, of course, to Professor Brazil for inviting me. And I'm very happy to see you here again after Salamanca. And even if it's only online, but I hope that we can meet in the soon future again in live, face to face. It is always better. Yes, so I'm happy today to share with you some ideas of my research area. Since 5 or 6 years, I have a research group, an international and interdisciplinary research group on end-of-life topics with Germany, France, Italy, England, for instance, and also India. But yeah, until now we have no countries in South America or even America, so maybe we can also get more impact of other countries on this topic. So yeah, this research work is generally on end of life in a pluridisciplinary and in a comparative way. But now, of course, the sanitary crisis of the COVID-19 unfortunately yeah, gives gives new aspects to this research area. So my topic today is the fundamental right to dignity until death and the difficulty to guarantee this right during the sanitary crisis. So the right to life and care in a crisis situation with limited resources. The problem is here that we have only limited resources, and I think in a country such as in Brazil, but also in France, in the last months, we saw that that is really a big problem to have to handle with this limited resources in the health area. So you can shift to the next slide, please. Yes, thank you. So I will just explain you the outline of my lecture in a very short way. So after a short introduction, I will speak generally about ethical and legal principles at the end of life from a comparative law perspective. And in a second time, we will see what has COVID-19 changed in the application of end-of-life rules in the situation in the European Union, with especially also the prohibition of unreasonable obstinacy versus the triage issues that are so important in the COVID pandemic. We will talk also briefly about the patient's autonomy and the dignity of the patient before my conclusion. You can shift to the next slide, please. So the right to life is one of the most important human rights, guaranteed in the constitutions of our different national countries, so in our national constitutions, but also in the Charter of the Fundamental Rights of the European Union and in Article 1 of the European Convention of Human Rights. In health, so we have this most important right to life, but there's also a right to health, which has been developed as a second generation human right. In a health crisis situation, the primary task of the state is to prevent imminent harm and protect the health and life of its citizens. In the corona crisis, its action consists of reducing the risk of infection by restricting individual freedoms. We saw this in the last months, I think, in all of our countries, with the lockdown, with the curfew, and all the other restrictions of our freedom. And and organizing also the medical care of the infected patients. But one of the fundamental human rights is also that of self-determination of the human person over her or his body and life and the individual freedom. Each human being has full power over their bodies, including the right to choose interventions on their bodies in all areas, for example, mutilation, health, and ultimately life. This right derives from the constitutional principle of the absolute protection of human dignity and the general right of personality. The guarantee of freedom also includes the human right to make free and self-determined choices in all areas. This principle of respect of the autonomy and will of the individual has constitutional value. It is enshrined in numerous texts at the national, European and international level. So the European Convention on Human Rights and the Charter of Fundamental Rights of the European Union enshrine in the Article 1 the principle of human dignity and self-determination of the human being. However, it comes up against the fundamental principle of the absolute protection of life, which is at the heart of our constitutions, in all our national constitutions, and also in the European Convention of Human Rights, Article 2, paragraph 1, and the state has an obligation to protect life as the most precious possession in the Constitution. You can shift to the next slide, please. So, at the same time, however, it must preserve the human dignity and freedom of action of every person. So, I will shortly present the end-of-life legislation in our country. So, in France, we have a new Act on End-of-Life of February 2016. In this Act, all aspects of end-of-life are regulated. The regulation concerns also civil relationship between the patient and the medical team and the physician, also criminal law aspects and public law aspects for public hospitals and the healthcare organization. In one of the key articles, key dispositions of this Act, it says every person has a right to have a peaceful end of life and to be accompanied with the best appeasement possible of suffering. So this is also one aspect of the dignity of the person, the dignity until the death, that the person is not suffering until the death and can find a death in a peaceful way. We saw with all this dying people during the COVID pandemic that it is of course impossible to guarantee to every ill person with the COVID-19 to have a peaceful end of life, because all hospitals are overcrowded. We have not enough medical teams to take care of this patient, and the family is not allowed to see the dying people. So very often these people are alone in a hospital without any support of the family because of the risk of infection. And so we can really not talk about a peaceful end of life in this case. So all these very beautiful principles cannot be respected in the case of the COVID pandemic. You can shift to the next. The other fundamental principles of the new legislation in France are the interdiction of unreasonable therapeutical obstinacy, the recognition of the patient's right to receive palliative care, avoiding or reducing his suffering. And that's also in COVID very difficult, because we say, okay, the patient has a right to receive palliative care, but palliative care needs or see a lot of medical teams, hospital beds in hospitals, or mobile medical teams that give palliative care at home of the patient. But this is pure theory in the case of the COVID-19. It contains also legal rules that are authorizing deep and continuous sedation until death. So that is a step further than palliative care, because with a continuous sedation until death, the person may fall in an artificial coma, and the communication is very often in this case stopped. The communication with the medical team, but also with the family. And it can also have a side effect to shortening the life of the patient. This is authorized by the law today. It is not assimilated as measure of euthanasia that is still forbidden in France. And the last point is the respect of the patient's dignity until his death. So this is a summary of all these different aspects that should guarantee the dignity of the patients until the death. So the respect for the patient's will may be also incompatible with the protection of life, because if the patient wants to die, the protection of life is not respected here. But in order to reconcile these two constitutional values, a legislative system has been developed, which by means of procedures such as advance directive, trusted person, collective decision-making procedure, and so on, tries to take the hypothetical or real will of the patient into account as well as possible, without betraying the fundamental principle of the protection of life. You can shift to the next slide. Yes. So also the ethical principles for palliative care are written in this act in France. So the principle of beneficence, acting in the acting in the patient's interest, the principle of non-malfeasance, no harm or impose unnecessary burden upon the patient by medical treatment. The autonomy of the patient is the patient's right to self-determination and to make informed choice. He has also to be informed about his health situation. And the last principle, but the most important in this COVID situation, is the principle of redistributive justice. That means that the same medical treatment for all patients in similar circumstances, and definitely this is not possible during the pandemic, because we have too many patients in the same situations to treat all patients in the best way and in a similar way. So you can shift to the next, please. The respect of the patient's will is also the right to be informed about the state of health, to respect his advance directives, and maybe a person of trust if the patient has designed a person of trust. The difficult balance here between the obligation to protect every life and the self-determination of the person over his or her own body and life is a profound expression of constitutionally guaranteed human dignity and freedom. It is decided by the legislator in each country differently and reflects the prevailing religious and cultural values and influences. You can shift to the next slide. So, the advance directive are mandatory it is a written document, and the patient has the possibility to use a form template. The patient can modify totally or partially the advance directives at any time, and they have an unlimited duration if the patient doesn't cancel or modify them. ADs take precedence over any other testimony, so also over a person of confidence. We can shift to the next slide. Yeah. In the other states within the European Union that are influenced by Christianity, the laws has historically been marked by the principle that the human body is intangible and not available, not even subject to the will of the person. The current strengthening of the right to self-determination in Europe changes this concept and opens up new perspectives for personal freedom. So, for example, in Great Britain, we have not, such as in France, one act who determines all aspects of end of life, but here we have only some different acts. So the Suicide Act of 1961, the Terminal Illness Act with provisions of palliative care of 2017, and the Access to Palliative Care Bill of 2017 till 2019. Yeah, but we have in Great Britain the same tendency to for more respect of the will of the patient, of the autonomy of the patient, more obligation to inform the patient, yeah, and less protection of life at any cost, even against the will of the patient, and if the patient is suffering and no care is anymore possible. So, yeah, we can come to the next slide. It is just a short overview of the legal situation in Germany. We have the law for the strengthening of the palliative and hospice care of the patient of 2015. So palliative care is also a very important aspect in the German law. Also, we have another provision in the civil code on the contract between the patient and the medical team, with also more rights of the patient. And the Act of 2009 on the advance directives and on the strengthening of the rights of the patient of 2013, and again the criminal law that is in a criminal code. Can shift to the next slide. Yes, so however, the respect of all these rights of the patient, right to autonomy, right to be informed, right to have the best health care, right to palliative care, and so on. All these rights in an exceptional situation such as the COVID-19 pandemic, with overflowing hospitals, insufficient means of care in many countries, and emergency decisions, is made very difficult, if not impossible. In an emergency situation, there's no time to search for the will of the patient, to hear the person of confidence, to find the advance directive, and so on, and to follow imposed procedures. The first aim is to save lives as soon as possible. The situation, so the protection of life as an absolute and constitutional granted right, is not possible in a situation of the pandemic. I just have a short overview of the situation in France and Germany. I know in Brazil the situation with the pandemic is very, very difficult, but in France we have also a difficult situation. In France we have 5,000 intensive care beds, and now they created 1,000 more beds, so we have 6,000 beds now, but until today they are all full. Yeah, the situation is okay because we have enough beds, but if more patients will come, the situation will be very, very critical. And the situation in Paris, in the big cities, it is even worse because we have not enough beds here. So the patients are obliged to go to other cities to find intensive care beds. In Germany, the situation is quite better because they have a lot more beds. They have 25,000 intensive care beds, and they are not full because they have around the same situation as in France. They have around 6,000 beds full, but they have enough beds free. And so they take patients from France, from Italy, from Belgium, and they transport these patients to Germany because they have even free capacity until now. But what we can do if enough intensive care beds are not available? What are the criteria for selecting patients for intensive care? And who should you leave to die? The selection is against the principle of absolute guarantee of life in the respect of the will of the patient. But if there are not enough resources available to help all citizens in need, how can there be a fair selection of people to whom the available help should be given? Should the selection be based on the criterion on the best chance of recovery, the age of the patient, or the estimated time left to live? You can shift to the next, please. So the possible criteria could be the age of the patient, the chances of survival, the healing success, but maybe also the social situation of the patient, if he is parent, if he has a lot of kids, a big family to take care of, or the social situation if he is, for example, a very important researcher and we need his research results for the future. Is it more important to give care to a very important physician or another scholar? Does he has more right to take care than, for example, a factory worker? And the family situation, does someone who has a lot of kids and is married, has he more right to take care than someone who lives alone and has no family, no kids? I don't know. It is a very, very difficult situation. And according to the latest statement by the German Council of Ethics, the state should be prohibited from prescribing selection criteria, as in principle all human life is equally protected. To weigh life against life is constitutionally inadmissible. The statement gives physicians considerable leeway, but also imposes considerable responsibility. For physicians, selection is associated with a conflict of duties, a possible violation of professional ethics, and the risk of criminal liability. You can shift to the next slide, please. So, who has to take the decision? Is it a decision of the medical practitioner, the legislator, or the ethical committee? The principle of the best use of available resources should be, in my opinion, the guiding principle. If a ventilator can save several lives in a row, instead of leaving the ventilator on one patient for a long period of time, should it not be used for several patients over shorter periods? For me, the medical practitioner is the one who is the closest to the patient, who knows the situation, the social situation, the professional situation, and the health situation, of course, of the patient. For the legislator, it's very difficult to intervene. But maybe the ethical committee could give some guidelines, or develop some guidelines for the physicians, for the medical team. More difficult even is a situation where one ventilator is already being used by a patient with a poor chance of survival, or a very elderly patient, and another is admitted, or younger, or with a better chance of survival. In this case, is it justified to stop the treatment to benefit the younger patient against the will and the wishes of the patient and his family who will die? All these are very, very difficult questions, and today I have no answer to this, of course, you can imagine. But I think it is good to discuss it, to be prepared to the situation. And the pandemic, before it was only a theoretical discussion. But I think the pandemic, the COVID-19 pandemic, showed us that it is reality now, and we need to answer to the questions. And I think also that an international discussion could bring us a lot, because if each country will do his own ruling for these questions, it seems to be very difficult. I think comparative law and discussion between the different countries is a very important point here. So the last slide is my thanks to you for your attention and for inviting me. And I'm of course here to answer, if possible, to your questions. Thank you very much.
Congratulations, Professor Stephanie Dijou. I was very pleased to listen to you and for your lecture. And of course, it's so interesting that we may continue our conversation in another opportunity with more time, because here in this seminar I'm a little bit worried because we have Elena from Russia. I know it's late in Russia, and I do not want to not let her to sleep, of course, but I think it's very interesting. And the question is the principal question: who has to take the decision? It's difficult. It's really very difficult, because if you see, the fundamental right is for everyone, doesn't matter the age. Doesn't matter the age.
Of course.
Yes, and it's very difficult. And if we call a rule of law, in the rule of law, everyone has the right to the fundamental rights.
Of course.
But we shall continue, and I would like to say that we are very interested to make an academic agreement with Paris-Nanterre. I already spoke to scholar Otto Marcel. Please give him my regards. And I think it will be very interesting to join our networks, our net research works between our countries. I think it will be very lovely and to exchange informations. So, Stephanie, thank you very much from the bottom of my heart. Thank you very much, and we shall continue. Thank you.
Yes, just one word to finish. So thank you very much for the invitation, and I would like to invite also all my colleagues, also from Brazil, but also of the other countries. We have this research group on end of life, and if someone is interested by the topics, each year we are publishing books on it with different articles. So if someone wants to join us to publish an article within our books or to take part in a seminar, or please contact me. I would be very interested to give the opportunity also to other countries, because until now we are only 5 or 6 countries, but it would be very interesting also to work with other countries and see how is the situation in general, not only in the pandemic but also in generally in end-of-life legislation of these countries.
Oh,
thank you very much.
You're welcome. Thank you for your invitation. Very interesting, and I shall be writing for you very soon about this.
Thank you.
Thank you very much. Well, thank you. And now I would like to call Elena from Russia. Elena is a lecturer from Russia, from Diplomatic Academy of the Russian Foreign Affairs from Moscow. And Elena is going to talk for us about cross-comparative review. After you explain what it means, the letters, practice in cases of favorable ecological environment. So, Elena, be welcome, and we are all here to listen for you. Thank you for accepting our invitation.
Thank you so much. I truly appreciate this invitation, and thank you so much, because I can explain everything, but for the last period of time, I published few articles dedicated to the right to health, and what was talking right now, Stephanie, was completely close to my investigation, and I do have also materials for the articles, and I do have materials about the favorable environment and the right to favorable environment. And for me, it's a great honor also to be published in few journals in Brazil for the last period of time with also my colleagues, and I truly would like to say many thanks from the bottom of my heart, that it is very important to strengthen our cooperation and to have this possibility not only today but in the future to share our ideas, our views, our positions, and that's just truly amazing that COVID-19 gave us this opportunity to travel around the cyberspace and to present the materials without traveling and going. And I hope that one day all of you who today participate in this event can have this opportunity to come to Russia, to the Diplomatic Academy, to MGIMO University, and to other universities to have this platform for the discussion, and also to publish your article also in our journals in Russia. That's why please accept our invitation in the future, please. And I'm going to say a few words for the beginning, that this article, which I published recently about the right to healthy, favorable, secure, and many other things, it was one of very interesting phenomena, legal phenomena for the last period of time. The ecological cases of the European Court of Human Rights and the environmental risk of gene-modified organisms. This article, which I was published, was dedicated, and I was considered the guarantees of protection of such a fundamental human right, or the fourth generation, as the right to healthy and quality environment. The focus was on the jurisprudence of the European Court of Human Rights in environmental matters. The article also was touches positive obligations, in particular the obligation to provide access to essential information, enabling individuals assess risks to their health. And also it was included the discussion from a human rights perspective, the right to a healthy and quality environment. And also I would like to consider the criteria on relevance, applicability, environmental cases. There the pollution is directly caused by the state, or then state responsibility arises from the failure to regulate adequately the private sector by the state. Particularly, focus is placed on the category of Russian cases related to plants operation and about the norm air emissions, as well as the consequences of the Chernobyl nuclear power plant disaster. And also, I would like to analyze the European Union policy regarding the regulation of production and turnover of products containing genetically modified organisms. That's why I would consider the European Union Charter of Fundamental Rights on a high level of environmental protection and environmental quality improvement should be integrated into the policy. And also the European Union wants to become the green continent in the world in near future. That's why they adopted a lot of great legislation, and the documents were truly interesting to analyze. And and I would like to say that I'm working on biotechnology issues for the last period of time, and right now I'm writing another article about biosecurity, and I'm comparing with agriculture security and digital security, and also the digital rights and many other things which are very important. That's why I would say that at both the global level and the European scales, the need to acknowledge a new fundamental right, namely the right to a healthy and balanced environment, is a relatively recent development. From a human rights perspective, the right to healthy and quality environment is a fundamental right. Those nature and characteristics do not change all the time. Although the convention or its additional protocols do not have provisions directly related to the right to healthy and sustainable environment, the European Court of Human Rights in its jurisprudence and the European Commission case law data has recognized that certain types of environmental degradation with serious consequences for individuals, or even the failure of public authorities to provide information on the environmental risks to individuals, may constitute a violation of certain rights protected by the Convention, provisions such as the right to life, prohibition of torture, the right to private and family life, or the right to property. And also I would pay attention that speaking on October 24th, 2020 at the events to celebrate the 75th anniversary of the United Nations, the UN Secretary General Antonio Guterres noted that this decade and has been declared the decade of ecology worldwide. At present, principles related to sustainable development are most fully codified at the informal level in the draft convention established in 1995 by the Commission on Environmental Law of the UN in cooperation with the International Council on Environmental Law, and in the Declaration of Principles of International Law related to sustainable development adopted in 2002. It should be noted, however, that theorists classify environmental rights as the third or fourth human rights generation. In particular, the right to a healthy environment, the right to freely seek, receive, transfer, produce, and disseminate information about the environment, legal phenomena and processes, etc. And the fourth generation of rights often includes the rights of humanity to peace, nuclear safety, peaceful exploration of outer space, environment, and etc. And I will say that from a human rights perspective, the right to a healthy and quality environment is a fundamental right. Those nature do not change all the time. Although the convention or its additional protocols do not have provisions directly related to the right to healthy and sustainable environment, and the European Court has recognized that certain types of environmental degradation with serious consequences for individuals, or even failure of public authorities to provide information on the environmental risks to individuals, may constitute a violation of certain rights protected by the convention provisions, such as the right to life, and also, for example, discrimination. With regard to environmental protection, the European Charter on Fundamental Rights stipulates that a high level also should be integrated and guarantee the principle of sustainable development. Among the 17th Sustainable Development Goals are environmental issues considered in goals number 3, 6, 12, 13, 14, 15, 16, and 17. And for example, goal number 3, good health and well-being, ensuring a healthy lifestyle and promoting well-being for all at any age Specifically, there is a need to reduce morbidity and mortality from hazardous chemicals and pollution. It should be noted that the principle of sustainable development has become firmly embedded in the conceptual framework of international public law. For example, in one of the decisions of the International Court of Justice of the United Nations, Judge Vera Mantri, in a dissenting opinion to the decision that in the Gaptikov and Admaroj case, called it a new fundamental principle of modern international law. And the Sustainable Development Goals are a call to action aimed at improving the well-being and protection of our planet. States recognize that measures to eradicate poverty must go hand in hand with efforts to combat climate change and protect the environment. The indicators are provided into major groups: indicators of social aspects of sustainable development, indicators of economic aspects of sustainable development, indicators of environmental aspects of sustainable development, including characteristics of water, land, atmosphere, other natural resources, as well as waste, indicators of institutional aspects of sustainable development, programming and policy planning, scientific developments, international legal instruments, information support, strengthening the role of key population, and striving to become the first climate neutral continent by 2015 under the European Green Deal. European Union states are considering the possibility of adopting a European climate law aimed at referring political statements in terms of legal obligations and investment incentives. I would say that Russia, for the last year also, was completed the obligation with Paris agreement, and I would say that we reduces the third part of the gas pollution last year, and it was the great result according to the agreement of climate change. Moreover, I would say that right now the European Court of Human Rights, considering the collective claim from 6 Portuguese young companies against 33 European countries for their actions, especially for the plans, for the idea that they are changing and they're helping to increase the temperature on under the territory of the European countries. And that's why I would say that it is a really interesting trend to see that collective claims can be also considered by the European Court of Human Rights right now, and we will see the result in near future. Also, in its jurisprudence, the European Court of Human Rights, while considering cases related to the protection of the right to an environmental favorable for health and well-being, relies on Article 2, right to life, and Article 8, right to respect for private and family life, inviolability of the home, of the Convention for the Protection of Human Rights and Fundamental Freedoms. And it's noted that Article 8 of the Convention is used much more frequently, and there is also little practice of applying Article 2, right to life. In some cases, we will see that also in Russian Federation, most of the cases was right to life was considered. And another article of Article 3, prohibition of torture. Environmental cases before the European Court of Human Rights are categorized as cases where poor environmental conditions are harmful to human health. As the court notes in its jurisprudence, there is a close connection between the protection and preservation of the environment and the human right to health. Thus, the convention doesn't cover an explicit established right to clean and quiet environment. However, if human beings have been directly and seriously affected by the environmental pollution, these may entail a violation of the rights enshrined in articles. And a substantial complaint shall be made if the environmental hazard reaches a level resulting in significant restrictions of the ability to live at home, infringes the right to privacy and, for example, family life. And the assessment of this minimum level is relatively and depends on all the circumstances of the case, such as the intensity and duration of the inconvenience, as well as its physical or mental impact on person's health and quality of life. Article 8 applies to environmental cases. There, the pollution is directly caused by the state, and then state responsibility arises from a failure to regulate adequately the private sector. I would say that it's very important to pay attention to the state's positive obligations under the Enabling Environment Convention. For example, the court's reliable principles for the environmental cases are broadly similar. For instance, in terms of affirmative obligations, the state must take reasonable and appropriate measures to protect the rights of the applicants, and in case of public authority intervention, both contexts must take into account the fair balance between the competent interests of the individual and society as a whole. And in both contexts, the state enjoys some discretion in determining the steps to be taken to ensure compliance with the convention. Some cases in this area have been dealt with under Article 2 and a positive commitment of the state to take all necessary measures to preserve life. In the context of hazardous activities, special attention is paid to the rules associated with the characteristics of the activity in question, especially with regard to the level of potential risk to life. The rules should regulate the licensing, establishment, operation, security, and supervision of activities, and mandatory implementation for all interested parties to ensure effective protection of citizens whose lives may be at imminent risk. Among preventive measures, particular attention should be paid to the public's right to information and established by the European Court of Human Rights jurisprudence. Regulation should also provide for appropriate procedures taking into consideration the technical aspects of the activity in question to identify weaknesses in the relevant processes and any errors by the responsible persons and different levels. Where state is
Elena, I think your video and audio we cannot hear. I think it's the internet traffic. Try again.
Oh, can you hear me right now?
Yes. Now it's all right. Очень хорошо.
Okay, can you hear? Is it okay right now?
Очень хорошо.
Спасибо. Thank you so much. I'm very
Пожалуйста.
sorry, but I had no idea. I didn't mention that there's some problems with the connection. I will. Spasiba. So I would like to present the case Lopez Ostra against Spain about pollution caused by noise and smells from a recycling plant. The European European Court of Human Rights stated in 1995 that significant pollution of the environment can have an impact on the well-being of individuals and to prevent them from using their dwellings in such a way that it can adversely affect their private and family life, nevertheless, without creating a serious threat to their health. And it made, on the basis of Article 8 of the Convention, a decision obliging the Spanish authorities to pay 4 million pesetas to the applicant in damages. And Article 8 of the European Convention of Human Rights states that everyone has the right to respect for his private and family life, the inviolability of his home, and the privacy of correspondence was also applied by the European Court in the case Giacomelli against Italy, which concerned a plant for storage and reprocessing of toxic industrial waste. The court held the infringement of the right to inviolability at home are not limited to specific or physical violations such as trespassing, but also include violations that are not specific or physical, such as, for example, noise, pollution from industrial activities, environmental accidents, nuclear tests, waste pollution, odors, and other types of interference. And a serious infringement may result from a violation of a person's right to the inviolability of his home if it prevents him from using the amenities of his home. And Article 8 of the Convention can be applied in environmental cases if pollution is directly caused by the state, or if the state's responsibility arises from the failure to properly regulate private activities. It is rather remarkable that in the case of Giacomelli against Italy, the court generalized some of its previous judgments on the environment. For example, Powell and Reiner against Great Britain, and the European Court declared Article 8 of the Convention is applicable because it considered that the quality of applicants' private life and the limits of the dwelling amenities were disturbed by the noise generated by the planes used by Heathrow Airport. In the case Guerra and others against Italy, we will see that the European Court of Human Rights noted that direct impact of toxic emissions on the claimant's right to respect for the private and family life means that Article 8 of the Convention is applicable. We would like to take also the next categories of the ecological cases against Russia. That's why the key political documents defining priorities, goals, objectives, and mechanisms for their achievement on the economic, social, and environmental components of sustainable development, covering the areas of sustainable development goals of the 2030 agenda. The environmental doctrine of the Russian Federation was approved by the order of the government of the Russian Federation, and the strategic goal of state policy in the field of ecology is the preservation of natural systems, maintaining their integrity and life, supporting functions for the sustainable development of society, improving the quality of life, improving the health of the population and the demographic situation, and ensuring the country's environmental safety. They were mainly related to plants operations, for example, Fadeva against Russia, and above the norm air emissions, I would say Lydiva against Russia, as well as the consequences of the Chernobyl nuclear power plant disaster. In the case Fadeva against Russia, the complainant alleged violation of Article 8 of the Convention says she lived about 450 meters from the largest steel plant in Russia, and the plant pollution caused serious damage to her health and well-being. The European Court concluded that for a considerable period of time, the concentration of various toxic elements in the air near the applicant's house significantly exceeded the established norms, the court found a violation of Article 8 of the convention and ordered Russia to pay 6,000 euros of compensation. Another case also is very interesting. In 2002, European Court considered Burdov complaint and who did not directly alert a violation of Article 8 of the Convention, but the case is clearly linked to the right to a favorable environment. The applicant was a Chernobyl liquidator. There he was forcibly taken as a soldier and suffered from overexposure to radiation. He pursues the case in the European Court of Human Rights, claiming that the decisions of the Russian courts granted him fair compensation were not enforced for an unreasonably long period. The judges anonymously found a violation of the right to a fair trial and ordered also 3,000 euros compensation. It recommended that the Russian Federation revise laws that are not in conformity with the international conventions it has signed and pay money to the Chernobyl liquidators without citing a lack of funds. The decision issued by the European Court of Human Rights, Malinovsky against Russia in 2000, for example, 5 and also marriage detention. The applicant complained about the prolonged execution of the Russian court's decision. In Malinovsky case, housing was not provided for a long time, contrary even to domestic law. And also, I would say that, in fact, from a long period of time, 5 years, the applicant and his family lived in an apartment with inadequate living conditions. And in 2001, the European Court recognized Mr. Malinovsky's right to an apartment, but he didn't get a warrant until 2004. As a result, the court, as in the case of Burdov, found a violation of Article 6 of the convention and awarded $3,000 or 3,000 euros compensation. It means the right to fair trial. Precedents cited only indirectly affect the right to a healthy environment. The claimants were persons who suffered from adverse effect of radiation, but their claims were caused by a violation of the right to a fair trial. And for example, I would say that we also can consider another type of the violations, for example, using the genetic modified organisms. For example, food and environmental issues are the joint responsibility of the European Union and the member states. The European Union environmental policy on GMO crops integrates production and consumption policies, calls for the adoption of new product technologies and circulation instructions, includes potential environmental risks of GMO production. The European Union remains, along with the United States, the main center of policy making for GMO market regulation and product sustainability. With a scaled-up scientific knowledge of biotechnology, the system of regulation of production and GMO products turnover changes substantially in Europe. The field of genetic research and genomic modification of living organisms and plant genetics is the area with the most stringent legislation, including countries, for example, like Norway, Iceland, and Switzerland. Nonetheless, GMOs continue to be used in agriculture, food, and consumer goods in the region. In Europe, any product containing more than 0.9 approved GMOs, which are very few, is considered to be genetically modified, or 0.5% for those still pending approval. Therefore, such products shall be notified accordingly on the package about their genetically modified nature. In contrast, for example, the United States, Canada, and Argentina, where labeling is required, only there's significant change in product quality or their health risk, for example, allergies. And moreover, the conventional supranational level of regulation and the ideological level of development of communitarian policies in the region are also in progress. For example, 1997 Council of Europe Convention on the Protection of Human Rights and Dignity of the Human Beings with regard to the application of biology and medicine, first raised by safety issues related to genetic manipulation at such a high level, including for medical and research purposes. This convention has provided the European Court of Human Rights with advisory judicial jurisdiction in order to protect the so-called fourth generation of human rights. And I would say that Russia also adopted, at the end of 2020, adopted the new federal legislation on biological security, which was included the genetic methods and, for example, gene editing crisps, for example, and also different kind of methods of genetic modified organisms in agriculture and at the same time in plants and animals on the human beings. That's why it's also a broad meaning right now in Russia concerning the ecology and also biology, both which are main consideration for the security of the population. And what I would say that, for example, it was adapted to a lot of directive regulations in especially European Union, and some, for example, GMO's definition in the directive stipulates that foreign DNA needs to be present in an organism for it to qualify as genetically modified organisms. Organisms that has foreign DNA removed do not qualify, even if gene editing has been used to make the organism. Of interest is the unified instrument based on regulation of 2003. And I would say that in general, the pan-European eco-regulation assumes that all GMOs are recognized as new food products. The European Food Safety Authority conducts a comprehensive, individualized and scientifically maintained food assessment based on 4 broad categories: safety, freedom of choice, labeling and traceability. In addition, for example, the European Parliament Committee on the Environmental, Public Health and Consumer Protection approved the safety first standard for GMOs, which entail liability for any adverse health effects. And as I'm going to say a few words at the end of my speech, I would lead to the conclusion. I would say that this practice of the European Court of Human Rights, in my view, very eloquently testifies to the fact that the right to a favorable environment, or the right to clean, the right to safe, the right to good quality environment is a complex legal institution, the violation of which is not always and not absolutely associated with the violation of the right to life or right to health. From a human rights perspective, the right to a healthy and quality environment is a fundamental right. Those natural characteristics do not change all the time. And also, the right to a favorable environment, the right to information on its state and environmental challenges, the right to compensation in case of injury may be subject to protection in environmental judicial institutions. For example, the European Court of Human Rights, and violations of these rights are the subject to complaint. Article 8 of the convention also used in environmental cases right to private and family life. And although the state is not always directly responsible for a specific violation, it can still be a respondent in action on the part of public authorities and the failure to take all possible, not only mandatory measures to eliminate or prevent an environmental threat that interferes with privacy is enough to apply to the European Court of Human Rights. And the cases on environmental rights violation are difficult in terms of the preparation and handling before the European Court of Human Rights. Harm to health or to life is not so simple to prepare the whole documents to prove that right and to find a link. And all this, we can see that the state authorities can also also keep some information in confidentially. At the same time, I would say that there are so many directions and challenges right now concerning not only eco cases, environmental cases, and also agricultural cases, and the right to health of the population. And we can see that this is a huge debate among the rights of the human beings, and at the same time we will see that it affects the global warming and climate change as well. I would finish right now my speech, and I would say thank you so much for your attention, and I hope that some inconvenience moment was not long period of time, and really thank you so much for inviting me and to give me the floor to express my last ideas which I was developed in different articles. Thank you so much.
You're welcome, Elena. Большое спасибо. And
Спасибо.
yes, and we are all very glad to listen for your lecture. And this is our first contact with the Russian lecturer, and hope that this first contact will continue with other lectures, other conversations. It will be very interesting. Well, because of the time, of course, we don't have much time, but I would like to say that we are very interested to make an academic agreement between our universities and exchange informations, lectures, articles. I think it's very interesting, and we shall talk to each other very soon. Absolutely. In the near future. Thank you.
Yes, I would say that absolutely we have to still keep being in touch, and we have to negotiate, because it will be great opportunity for our institution, for our academy, and for your institution to have the cooperation and to publish also common monographies, also to have some investigations in different aspects of the legislation. That's why with pleasure I will talk to my also chief. He is a head of the Department of International Law at the Academy about the agreement, and as we did with Argentinian University, we did exactly the same last year. We were expecting them to come to Moscow for 2 weeks, but unfortunately we had to cancel that trip due to the COVID pandemic situation. But we still have this opportunity to do it online, and later on we will have this opportunity to travel and to have this personal contact, face-to-face conversation. And thank you so much.
Thank you very much. Thank you very much, Elena. I wish you a good evening, and we shall continue writing to each other and strengthen the academic relations between our universities. Thank you so much.
We will, I promise.
Oh, thank you. Спасибо.
Спасибо вам большое. Благодарю вас. И большой привет.
Привет. I know a word in Russian. Я люблю Россию.
Я люблю Бразилию.
Thank you very much. Thank you.
Very similar in Macedonia. Yes, я любим Russia.
Very similar. Yes, I think both languages are very similar.
Slavic language,
yeah.
Right. It's a Slavic languages, that's why, Tatiana, thank you. We absolutely have a lot of things in common, I'm sure.
Oh, thank you. So I'd like to invite Mattia Damian. I know it's late in the evening because the time difference between our country, it's about 5 hours. So I think it should be 10 o'clock in the night in Slovenia, in the beautiful Ljubljana, a very beautiful town. I also visited Bled Lake, beautiful places. Piran, it's a very tiny resort town, very beautiful. So, Mattia, be welcome to our university, and we are all also very pleased to listen to you. So, it's up to you, my friend.
Well, thank you very much once again for the invitation, for giving me this opportunity to address your students and everyone else here. It's a great honor, of course. Now, my colleagues before me spoke about some fundamental rights, and I want to speak about one of the fundamental rights as well, the freedom of speech online. Let me share just a few slides with you. It should be this one, right? Yes. Okay. Can you see that?
Yes,
Yeah.
perfect.
You can see my slides. Okay. Now, I think when we first spoke about this, it was sometime after President Trump was kicked off Twitter and Facebook. So I said, maybe let's talk about free speech online, which connects to one of the issues that I have researched before. Now, freedom of speech is one of the fundamental rights that is guaranteed in the member states' constitutions in Europe, and of course in the common documents such as the EU's Charter of Fundamental Rights, and also in the much older European Convention on Human Rights that we also heard something about today. So freedom of expression, yes, it's a fundamental right. It applies everywhere. It also applies online. And in fact, the internet and social networks in general are a very good tool, a very appropriate venue for exercising that right, the freedom of speech, and people actually do exercise it there. Twitter, for example, has become quite an important value for expressing political opinions, for example. But we know, as any fundamental right, freedom of speech is not absolute. It's limited by rights of others, and as nicely said in the European Convention, it carries with it duties and responsibilities. And so this is what we're interested in here. Which are the cases where freedom of expression might be limited online, and particularly the mechanism in which it may be limited. And of course, this is always of a constitutional, a matter of constitutional importance, because fundamental rights should be limited to the very limited extent. Limitations should be limited. Now, the sort of communication that doesn't deserve legal protection is the one that violates some other rights to an extent that is not acceptable. So I'm not a constitutional lawyer. I'm myself, I deal with private law, so I will mostly deal here with violations of various private rights, such as the right to privacy, violations of personality rights, of trade secrets, intellectual property rights. All of that can be violated online by certain communications, certain information that is posted online. So examples of such illegal communication then are insults or defamation, which affects personality rights, hate speech, various invasions of privacy. We know we have many celebrity photo leaks, video leaks, and so on from people's private lives. And there's many instances where something is posted online that is protected by copyright or by some other intellectual property rights, and so this post will violate such IP rights. The result of such violation is that someone can request, so the affected person may request the removal of such content, or may claim damages. I'm telling you, I'm a private lawyer, so I work in the field of private law. So I'm not interested in criminal sanctions. I'm interested in the fact that we can sue someone and claim damages. So who can we sue? Obviously, the person who posted something, who posted online, but that's not really problematic. You can always go after the direct perpetrator of a certain violation of rights. But we also know what happens online. It's hard to find the person who posted something on Twitter. People are often anonymous. Even if they have proper names, it's difficult to connect that name with the real person. Maybe that person is located in a different country, and it's difficult to go after them in that country, or it's a nuisance at least. And we even don't know if whether they have any money, whether it's worth suing them. You know, under the deep pocket doctrine, we want to sue the entity that has most money, so they will be able to pay something. So the obvious question here is: can we sue someone else? Can we take action against someone else? And that someone else, obviously, it follows from the title of my lecture, would be the social network. Or generally, more generally speaking, any of the entities, the companies that work, that function as sort of intermediaries in the online communication. Because we know that information online doesn't come directly from one user to another one. There are a number of technical intermediaries between them. Everyone has some sort of contract with their internet access provider, and then there are hosting service providers, there are operators of online platforms and so on, and of course there are operators of social networks, Facebook, Twitter, Google, and so on. And they're the ones that we'll focus on, because notoriously Facebook is rich, Facebook is big, and if we want to prevent something from being published on Facebook, we don't want to act against the person who published that. If we have a more direct way how to go against Facebook itself. First, it's rich, and second of all, it has technical control of the content that was posted by its users. It can always block it. It can always remove it. So the legal issue is first, under what conditions is such an intermediary, the social network, required to remove any illegal information that was posted by its users, not by the network itself? And second, when is it liable for any loss or injury that might be caused by the breach of law caused by this information, by the publication of this information online? Now, within the European Union, the main framework for dealing with these issues was adopted 21 years ago in the Electronic Commerce Directive of 2000. Which established a uniform liability regime for any kind of liability for any sort of intermediary services online. So from internet access providers to providers of online hosting, and there are also some other caching services and mere conduit services and so on. But what we're interested in today, and what's mostly relevant in concerning this issue of liability of intermediaries online is the liability of hosting, of online hosting providers. And this legal framework under the e-commerce directive established a sort of safe haven for them. The legislators wanted to protect under what was at that time a relatively young technological environment, the internet. So they wanted to protect internet intermediaries against being too exposed against possible claims from people whose rights may have been affected. So they instituted a so-called notice and takedown system for online hosting, under which hosting providers are in principle exempt from liability for the content uploaded by their users, as long as they swiftly remove or block such content when they are notified of the fact that such content might be illegal and might violate another person's rights. So they have no obligation to monitor all the uploads by their users. They have no obligation to search for any illegal information, and member states are prohibited from imposing any such monitoring obligations, but they must act once they are made aware of the illegal information. Now, this legislation has been developed in the case law, and the European Court of Justice has generally protected intermediaries from being too exposed to any liability. Another issue was when can we say that an intermediary, still without being directly notified of a violation, could still be required to be aware of the illegal information. And the court held here in Google, in L'Oréal, Google versus L'Oréal, that this happens only in cases where the hosting provider had an active role in providing the illegal content. And in another case, Scarlett extended, the court also held that even a court injunction cannot impose upon a hosting provider the duty to filter any content uploaded by its users, but only the principle of notice and takedown. Well, that remains the main principle. So as a guiding principle, intermediaries remain exempt from liability as long as they retain a technically neutral role with regard to the illegal content. Well, should be here. That's the main source. So we can say that the providers are quite well protected against liability under this system. The users of their services, not so much, because the notice and takedown system is not regulated really. It just referred to in the directive, and it should be more directly regulated in more detail, I guess. So currently we don't know in what form the takedown notice should be given, in what form should it be given so that the provider is required to act and to remove the illegal information. And we also don't know if the service provider is entitled to assess the merits of the request for the removal, or if they are or they must act immediately. So the result of that is that service providers are generally inclined to remove any information for which they obtain a takedown request. And that is problematic because, as we said, social networks, the internet in general, are an important venue for exercising the freedom of expression. So if we have this mechanism for automatically removing everything you don't like from the internet, That's a sort of censorship, and it has been misused in this way. For example, videos posted on YouTube that are critical of some companies have been taken down because those companies have required a takedown, required the removal of such videos by claiming that the videos violate their copyright. So they didn't actually reveal the real reason that they don't like the critical content of that video, but they just claimed something else and they were successful. So this amounts to a sort of private censorship without any court control. So we'll see what happens with that in the future. Now, as I said, the regulation, the e-commerce directive is now quite old in internet years. 20 years is a lot. At the time when this was adopted, social networks didn't exist even. And the idea of hosting was totally different then. It was considered a merely technical activity where you host content for someone else, for the user of your services, probably against payment. And now social services arose. They've been here for social networks. They've been here for, 15 years, 20, almost 20, not yet 20 probably. And their role is actually different. The line between the service providers and content providers is quite blurred, because social networks, of course, don't provide the content themselves, but they count on the fact that users will upload it, that they will write stuff online, and they will actually sell their users' content to others to obtain, clicks, to obtain attention, and in that way sell ads mainly. So for a social network actually benefits from all the information that is published by its users, even if the information is illegal. For that reason, there was much lobbying in the European Parliament and so on to somehow make more strict the legal liability for social networks for any illegal publications, to force them to act in a way to prevent, aimed at preventing publication of illegal information. And copyright holders were the first to succeed in this fight. So in 2019, after much discussion, the directive on copyright in the digital single market was adopted, which introduced a new category of internet intermediaries, which are called online content sharing service providers, which are defined as services whose main purpose is storing and giving to the public access to a large amount of copyright protected works that are uploaded by the users, and which the service provider organizes and promotes for profit-making purposes. So it sounds just like a social network, which is exactly what was meant to be captured by this term, which is also demonstrated by the fact that any non-profit online encyclopedias are, such as Wikipedia, are expressly excluded, and any other similar non-profit activities. So, what's the new system of liability for social networks? This principle applies only for violations of copyright, not for any other types of liability. So social networks are now required in principle to obtain authorization from any copyright holders for any content that was uploaded by their users. So the idea is that whenever users of a social network upload copyrighted content on that network, it's the network that's actually using the copyrighted works, so it must obtain authorization. And the idea is that the networks will get actually some sort of flat rate licenses from collecting organizations, not that they will negotiate with every individual copyright holder. Now, what happens if they can't get authorization because, for example, the author is not represented by a collecting organization. In that case, they can still avoid liability for such content if they prove that they have exerted best efforts to obtain such an authorization, and if it wasn't obtained, to obtain best efforts to avoid the availability of unauthorized works, and lastly, if they can prove that they have acted expeditiously to remove such content once they have been informed of it. The issue that's very controversial and not yet resolved is whether these best efforts in avoiding the availability of unauthorized works also includes the requirement to install upload filters that would automatically filter any illegal content that violates copyrights. We don't know yet. It was promised that it doesn't require that. That was a very controversial issue, but we'll see how that develops in practice. I think the directive has not been transposed into national legislations yet, so we'll see what happens. But the legislation hasn't stopped yet, and just recently, I think it was in December and January this year, the Commission has proposed a new Digital Services Act, which will be a new EU regulation that will actually totally overhaul the existing system of liability, the one from the e-commerce directive, and it will introduce additional provisions for providers of hosting services. What's good is that the mechanism of electronics of this notice and takedown system is better defined. It's now referred to as notice and action system, probably just because notice and takedown is an American expression, so we need something different. It's now called notice and action in Europe. Before that, it didn't have an official name, but we use the notice and takedown expression, which we're used to from American law. And now the proposed act requires such a takedown notice. It requires the person who is affected by a certain information published online to explain why they think this information is illegal, to define the online location of that information, to identify themselves as the right holder, and to state that they are providing this information in good faith, so that it is true. So that may even be potentially criminally liable if they're requiring a takedown of an information that doesn't violate any rights. On the other hand, the user's rights, we're talking about the user who posted such information online, should be protected by a statement of reasons that must be issued by the social network, by the hosting provider, providing the reasons why such information has been removed. There's no other legal remedy for that, but at least you know the reasons. This is what applies to any hosting service online. And now we have two new categories of hosting services introduced by this new act. And those are online platforms and very large online platforms. Online platforms are something very similar to the content sharing providers under the Copyright Directive. So these are hosting services which store and disseminate to the public information uploaded by the users. And very large online platforms are another way of saying Facebook, Twitter, and Google. So these are the platforms that reach at least 45 million average monthly active users. So that's roughly 10% of the EU's population. And so for these kinds of hosting providers, there are some additional requirements. They will have to adopt certain internal complaint handling system for dealing with the takedown requests. They will have to provide some out-of-court settlement process to review complaints against any removal of content that they have carried out upon such a notice. And they will have to institute a system of trusted flaggers, so sort of independent external expert entities that will report any illegal content that they might detect on the platform. And they will, the platforms will be required to process such notices with priority. So I might also mention that the trusted flaggers should be nominated by the public authorities and not by the network itself. And they must also institute some measures and protection against misuse of their services, such as expressly stated the suspension of users that frequently provide manifestly illegal content. So this is why President Trump is pictured here. Now, very large online platforms, so the major social networks, will also have some additional, everything that I've mentioned now will apply to them, but they will also have some additional obligations in terms of policy of their company. They will need to carry out risk assessments of their services every year. They will have to institute mitigating measures to protect users from illegal content, and they will be subject to independent audit. Now, what these mitigating measures are, we don't know and we're also worried that this might again lead to ideas of automatic filtering of all uploads online. Hopefully not. But finally, while we were discussing the new Digital Services Act, a new regulation on addressing the dissemination of terrorist content online has been passed in the European Parliament, and this one also allows the removal of any illegal content, in this case terrorist content, that might be published online, particularly on social networks. Now, this is not that interesting for me as a private law researcher, because this is public law issue. The network is required to remove something very swiftly within 1 hour of receipt, but that receipt will always be directed by public authorities, not by individuals. What we might be again worried is that the requirement that hosting service providers that are exposed to terrorist content, we don't know which those are, will be required to implement specific measures to identify and expeditiously remove or block any such content. What such measures are, I guess the case law will have to define that again. Now, thankfully, also this regulation includes some safeguards and accountability. Above all, transparency is required as to what has been removed and under what conditions. And also the person whose content has been removed will have to be notified of that, just that the competent authorities will be able to stay that notification for up to 6 weeks at a time if they want to keep it secret or so on. Now, I don't want to exceed my time too much. The main point is that up to now, the social networks have been quite well protected against any liability under the European law. Now, the new legislation will introduce, obviously, some new requirements. The good news is that the requirements are also of such nature that will also protect users' rights to some extent. But I think each time when we discuss these issues, we should not look at them very narrowly. From a narrow view, you know, the issue is just we have some illegal content, it violates property rights, it violates copyright, it's terrorist content, we want to get rid of that. But we should keep in mind, in a wider view, that, you know, it's very easy to say this violates certain rights and use that to remove any unwanted content from the internet, and that's already censorship. So any such issue that deals with removing content from the internet potentially affects the freedom of expression. So this is a sort of touchy issue, and whenever I speak to judges, about these issues, I always tell them, keep in mind that the internet is always also a tool for exercising fundamental rights, mainly the right to speech, and that's we have to keep that in mind. So that sort of concludes my presentation, and thank you for your attention.
Thank you, Mattia Damian, for your lecture. Very interesting about free speech, and I was just curious about who controls the censorship, because we have the censorship for the matters of internet, but who controls the censorship?
Yeah, that's always the main issue. One issue is here, if we want to rely on so-called trusted flaggers, who are independent institutions. I don't know, some faculties, for example, here in Slovenia, and we trust them that they will only flag the content that really violates certain rights. But they may use that, they may misuse that authority to further their own political agenda, and they're they're often accused of that. So how can we trust the trusted flaggers? You know, it's the quis custodiet custodes problems, as always. I think it's good that the state doesn't directly control that there's someone between state authorities or any private individuals. It's also good that the social networks are somewhat limited and will not be able just themselves to remove any content that they don't like. So a bit of transparency. I think transparency is the best policy here we can have here, but it's not. Nothing is ideal. Everything has certain issues.
Thank you, Mattia. And I remember that you are the editor-in-chief of the Journal of Institute of Comparative Law, Faculty of Ljubljana. I think it's Laptopis, Pravna Laptopis, the name, if I remember well. Yes, it's very interesting. I remember that I published an article at your magazine. It was quite good, and in person, in voice, I would like to thank you very much for that opportunity. It was very interesting.
Thank you for publishing that.
Yes.
Welcome.
It was wonderful. And do you know Ales Galic?
Of course.
Yes. Well, if you meet him, please, I would like to ask you if you could give him my best regards and wishes from Brazil, because when I was in Ljubljana, he was my advisor professor. Yes. And I would like to give him my best regards, and I shall invite him in the near future to stay with us, to talk with us here in Brazil. I think it's very important, this contact, even by internet. But as I said before, we intend, as soon as this pandemic situation ends, to invite each of you. Tatiana Zoroshka, I shall be inviting you. Of course, Stephanie Holfin-Dijou, and also Elena from Russia. And of course you, Mattia, to come to Brazil to visit us, but in a safe situation. And hope it'll be very soon. Well, I know it's late in your country. Here in Brazil, also we have classes for the night, for the evening. We have classes, so very soon we shall be having classes for the students. Well, thank you once again. I would like to ask Magno or Clyde, if you want to say something.
Please, Dayton, I want to speak a little words to free the free speechers. In first, I will present some considerations for us to think about. There's no need for a reply today because we are late in the time. To teacher Stephanie Dijou, congratulations. I really enjoyed the part of the lecture entitled Trial and Errors. These are excellent questions. The self-determination must be taken as long as the patient is conscious. One of the problems with the COVID-19 is how quickly the patient needs intubation. In addition, the possibility of the patient recover will only be checking during the intubation period. We have a problem, no? The same problem that you said today. How do you see the patient self-determination in this context, especially if the decision does not come from the patient, but the legislator, the medical? I saw that in the lecture you said there is no answer. Anyway, what would be the deadline for the life and death decision? Here in Brazil, we have a jurisdiction is very slowly. So I don't think the judge's decision is come in time. That's my opinion. No. To Elena, congratulations too. My research is also related to yours, especially the conclusions you presented here today. I have a written article requiring prior licensing for the production and commercialization of genetically modified organisms using the dimensions of sustainability and the principle of prevention to prove the non-offense to the health of people, animals, and the environment in general. So I will ask to the Hilton for your email to have a maybe we can write an article together. Thanks for the lecture too. To Mattia, congratulations too. Internet provider with civil liability is a very complicated issue here in Brazil. The competent jurisdiction is sometimes unable to enforce court orders. At this point, the restriction of the speech on the internet has been used as a means of social control here, in other countries too. So, how does the professor see the civil liability of the internet provider for fake news? So, because the fake news is another factor of concern in the democratic states of law. Thanks a lot for everybody. Thanks. For us, it was a pleasure to see you here today and listen all the lectures. Thanks a lot again.
Thank you.
If you want Mattia to say something, you are free.
Yeah, sure. Fake news, of course, is an interesting issue because it's problematic. We want to censor it, but it's not illegal usually. Sometimes it is, but very often just claiming something is just stupid. So that's, I guess that's the next issue. I'm not sure how we can deal with it in legal terms, but we haven't devised a good system of fighting that. Just possibly kicking off users. Perhaps that's the best thing for the policy of social networks. But you know, their motives, their financial motives might be different. They benefit from fake news sometimes.
Thank you, Mattia. So I would like to finish the seminar, and once again I would like to say my gratitude, my happiness to have such important lectures here. A very pleasant afternoon in Brazil with you all. So thank you very much, Tatiana Zoroshka Kamilovska, I think the name I learned, and but I spent 3 hours about training your name before. It's just a joke. Well, also, Madame Stéphanie Hoffing-Diju, je vais parler quelques paroles en français parce que la langue française pour moi c'est une langue très chère. Je respère très prochainement d'avoir l'opportunité de recevoir la professeure sur l'internet et bien sûr parler un peu en français. C'est une langue que il y a très longtemps que je ne parle pas, j'ai oublié beaucoup, mais je garde dans mon cœur cette belle langue. Merci beaucoup pour votre présence et j'espère te voir très prochainement.
Avec grand plaisir, merci beaucoup à vous et bravo pour votre français, c'est très très bien.
Merci beaucoup. Merci beaucoup. C'est toujours un grand plaisir. Merci. Je vous souhaite une très bonne soirée.
Merci.
Et à tout à l'heure. Et for Elena, many thanks. We are very pleased to have you. And of course, we shall talk to each other in another lectures, and it will be very important. So, now in Portuguese, eu gostaria de agradecer a todos os presentes que estiveram aqui, os meus alunos de mestrado, de doutorado, os visitantes, os palestrantes, enfim, a todos que estiveram aqui, muito obrigado. É que eu digo, a língua inglesa é uma língua difícil, mas temos que nos acostumar, temos que começar a falar, a começar a praticar, porque é essa a realidade, é a realidade da globalização, da internacionalização, em que nós temos que ir para que possamos estar recebendo os professores, melhorando a nossa qualidade de linguagem, de recepção. Well, for all, I wish you all a very good evening. I know it's late in Russia, it's late in France, Slovenia, Macedonia, from North Macedonia. All very beautiful countries and beautiful people, hospital people, and we love you all. Thank you very, very much. Slovenia has the name love in the middle of the name. So Slovenia, it's a wonderful country. Oh, thank you. A good night for all. Agradeço a todos e declaro então encerrados os nossos trabalhos.
Good night.
Bye bye. Da svidania, Helena. Da svidania.
Goodbye. Bye-bye.
Bye bye.
Bye
Bye.
bye. Bye.
Bonne nuit.
Ah, bonne nuit. Yes.